Here's a plain language explanation of Section 21 of the Cybercrime Act, highlighting the important legal protections it provides for individuals who publish or share content that others may allege to be defamatory, particularly in the context of online or digital communication. An excerpt of this translation and actual relevant subsections are posted in the description of this video. Subsection 5. Acceptable defenses against defamation charges. This part says you can defend yourself against a defamation charge under the Cybercrime Act if what you published fits one of these four situations. 1. It was true. If what you said or posted is true, you cannot be guilty of defamation. 2. It was for the public's benefit. If the information was shared to help or inform the public, for example, exposing corruption or wrongdoing, it can be a defense. 3. It was fair comment. If you were expressing an honest opinion about a matter of public interest like reviewing a public figure's performance or commenting on government policy and not making false claims, it can be defended as fair comment. 4. It was made in good faith. If you made the statement honestly without the intention to harm or deceive, that can also be a defense. In short, if you spoke the truth, acted for the public good, made a fair opinion, or acted honestly, you may not be guilty of online defamation. Subsection 6. These are questions of fact. This means whether your post or comment was true, benefited the public, was fair, or made in good faith is something that has to be proven with evidence in court. It's not automatically accepted. It depends on the facts of your case. Subsection 7. Burden of proof for good faith. If you claim that your post was made in good faith, the other side, the person claiming they were defamed, must prove that you were not acting in good faith. In other words, once you say you acted honestly, it's up to your accuser to show that you didn't. Subsection 9 refers to the Criminal Code Act. This clause says that the rules in Section 362(e) of the Criminal Code Act, Chapter 262, which protect people who publish information about matters of public interest, also apply to online defamation cases under the Cybercrime Act. So if you are discussing something that genuinely concerns the public, like government conduct or community safety, you get the same legal protection as if you said it at a public meeting or in a newspaper. Subsection 10. Online forums count as public meetings. Here, the law clarifies that a public meeting, as mentioned in the Criminal Code Act, now includes online discussions, such as posts or debates on social media or web forums. This means that legal protections for public discussions also apply to Facebook posts, online comments, group chats, or discussion threads, not just physical gatherings. In summary, if you post something online and someone claims it's defamation, point 1. You can defend yourself if what you said was true, for the public's benefit, a fair opinion, or made honestly. Point 2. The court will decide based on the facts whether those defenses apply. Point 3. If you say you acted in good faith, the other person must prove you didn't. Point 4. Public interest protections in the criminal code apply even to online discussions. Point 5. Public meetings legally include social media and online forums.